Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Please be seated.
Please call the case.
The fate of the 30-meter telescope project is now in the hands of the Hawaii Supreme Court.
811 and 812, INRI 30-meter telescope at Mauna Kea.
The court heard consolidated oral arguments last week. There are 3 separate appeals from the Board of Land and Natural Resources' decision to issue a Conservation District use permit to the University of Hawaii at Hilo for the TMT International Observatory on Mauna Kea. It was the second time the Supreme Court took up the issue of the Conservation District use permit. The first time was in 2015, after the project was first granted approval to build on the mountain.
There are certain fundamentals of just procedure which are the same for every type of tribunal and every type of proceeding. A fair trial in a fair tribunal is a basic requirement of due process. Justice must not only be done, but manifestly be seen to be done.
The permit was vacated by the court at the height of an intense struggle about Mauna Kea between both sides. The court said the state proceeded with the permit application improperly when it pre-approved the application subject to the results of a contested case.
Do you think that due process would allow a court for the judge to say, here is my judgment in favor of the plaintiff. We will now have a trial. And if you convince me otherwise, I'll change my mind.
The court ordered the land board to do it again.
So I welcome you all to the hearing we're having today. The hearing involves only the motions to intervene.
It has taken years, but the state managed to hold another contested case hearing.
Objection, there's no question asked.
I'm pausing to get the question.
Which again resulted in a land board approval.
Countervailing concern about footprint and density and visitation on the mountain.
And once again, the decision was appealed to the High Court. The lawyers had their chance to argue on June 21st. 30-meter telescope International Observatory attorney Ross Shinyama spoke about the impacts of the project to the summit area, where astronomy has been thriving above the clouds.
None of these impacts would tip, the TMT project would not tip the balance of any of these impacts from a non-significant level to a significant level. This court in Mauna Kea and Idaho, Kila, did bring up that the incremental impact of a project cannot endlessly justify the building of telescopes.
Okay, and well, help me. Where does it stop? Well, now we have a 180-foot telescope, and you take down 3, and then you put up a 300-foot telescope? I mean, well, Your Honor, where does it stop?
With respect to this project, we're putting up 1 and we're taking down 5, and that's part of special conditions 10 and 11. And so clearly, the record demonstrates that the board was clearly concerned with the cumulative impacts, and through this project and their approval, did attempt to address it and address the concerns that this court had both in Kila and Mauna Kea and Idaho.
Well, that raises another interesting question with respect to the mitigating conditions. Would you say that the mitigating conditions have now taken that substantial adverse impact to cultural resources, which I guess we accept as a baseline is there, absent this telescope, and move that baseline back so that now, given the mitigation, we can say that there's no significant adverse impact to cultural resources?
Your Honor, there's nothing in the record to demonstrate that, but what the board did find was that given the mitigation measures, specifically the decommissioning of 5 telescopes, that taking those into consideration, that the TMT project itself now will, with the decommissioning overall, will result in less overall impacts on the mountain.
Well, that's true, but
And
I
so
wonder if legally it has gotten back within the envelope that was anticipated by HAR 13530, where it says that a permit can't be granted where the project would cause substantial adverse impact.
Yes, the project itself, though, Your Honor, not the cumulative effects. And the criteria makes it clear that HAR 13-5-30 has to be considered in the context of what is already existing. And that's the same interpretation that the board used in Kila and that this court affirmed in the majority opinion in Kila.
And this court, in a published
decision.
While Richard Werdeman, the attorney for the original petitioners who have been fighting the TMT project all these years, focused his arguments on alleged procedural error.
And the first order that was issued was the appointment of hearing officer Ricky Mayamano. And that was on or about May 31st of 2016.
In particular, he argued that retired Judge Ricky Mayamano, who was the hearing officer chosen by the state to handle the second contested case on remand, had a conflict of interest that she originally failed to disclose.
Hearing officer Amano also included a very comprehensive of cases that she had been involved with, about people she knew, where she had gone to college, law school, all these various types of things. We objected to her. After some research, we discovered that through the internet that she was a dues-paying member of the University of Hawaii at Hilo's Hilo Astronomy Center. A party in this action, the University of Hawaii at Hilo, and of course the Astronomy Center is the subject of the dispute. We objected to her proceeding as such because of the obvious pronouncement of this court. She was a dues-paying member of an actual party in this case. And our objections were overruled. Subsequently, hearing officer Amano, in a subsequent disclosure after our objections were lodged, had in essence stated that she had been unaware that the Hilo Astronomy Center was part of the University of Hawaii at Hilo. And in our motion for reconsideration, we added photos that were online with a big University of Hawaii at Hilo sign right in front of the center. Our objections were overruled again. And the appellees in this case essentially argue that, this is just a casual, informal kind of membership. The crux of the whole thing is we would submit what the whole Mauna Kea 9901 was all about. It was about that cold stone impartiality, that appearance of justice. Whether you characterize it as a more casual family kind of membership, I think really begs the question, because where do we draw the line as far as due process?
Solicitor General Clyde Wadsworth defended the state's actions.
Petitioners cite no statute, rule, or canon that required Judge Amano's disqualification based on her family membership with Imiloa Astronomy Center, which is both an astronomy museum and a Hawaiian cultural museum. She simply held an $85 annual museum pass, which doesn't carry any more risk of prejudgment than having a Bishop Museum membership, being part of an alumni association, or even just visiting planetarium. And in her disclosures, Judge Amano made clear that she had no involvement in the control, management, or governance of Imiloa. In other words, she had no duty of loyalty. Her alleged relationship to UH was just too remote and tenuous to create an appearance of impropriety. And that's the standard we have here under Sussel, which asks whether the decision-maker's impartiality might reasonably be questioned. And
why do you think, if there was no reasonable impression of partiality, as soon as she was informed that the parties knew about it, she said, I'm going to cancel my membership? In other words, why would you need to do that if there wasn't already an impression of partiality out there?
Well, I think, Your Honor, she just wanted to assure everyone of her impartiality.
On behalf of the Temple of Lono and other individual intervener appellants who are opposed to the 30-meter telescope, Attorney Gary Zamber alleged his client's religious rights were violated by the university during the process.
Using terms such as The temple is fundamentally adversarial, ardently absolutist, using the proceeding to advance a religious agenda, religious fundamentalism, intolerance, inability to compromise, regardless of the harm it brings to the society of which it is a part. Essentially denoting an extremist religious fundamentalism, which, given the First Amendment to the United States Constitution, there's a prohibition for Establishment Clause purposes that government should neither unduly support or attack a religion.
Mr. Zamber, your argument to the hearings officer was that Hilo should be disqualified because of those comments, or how did you follow up, and what did you ask the hearings officer to do?
The temple at that time had asked repeatedly through a number of motions. First of all, filing a motion to file out of time was denied, and then to file a motion just to be heard. The issue was subsequently asked to be heard a number of times, and it was denied throughout. So that's where the issue becomes more important, because as a matter of due process, the hearing officer would never allow litigation of that issue. So
the issue being to disqualify them as a party, or what exactly relief did you ask for? To disqualify the university.
I see my time is up.
Mr. Manal, I do have a question. The language in here is pretty incendiary, and I'm just wondering, how can the public be comfortable that Hilo will actually continue to respect Native Hawaiian traditional and customary rights when it refers to the petitioner's beliefs as fundamentalist, and that they don't think about the harm it brings to the society? Why would you use language like this? I'm just wondering, how can the public have confidence in Hilo based on this language?
So legal pleading that we filed, the reply brief language, was referring essentially to the Establishment Clause and the law surrounding the effort to acquire a religious servitude over an alleged sacred location. One of the issues that was analyzed by the U.S. Supreme Court is the extent to which what is considered religious fundamentalism seeks that type of religious servitude. And what we were referring to was primarily a policy argument. It wasn't an effort, and we apologize if it was taken that way, but it certainly was not an effort to denigrate someone's religious belief. What our position was is that there is a religious fundamentalist position being pursued which seeks a religious servitude over the mountain, and that would run afoul of the Establishment Clause.
Do you think that is also the way the board perhaps, well, I'll just read you conclusion of law, I guess it's 282, and there's no requirement that people who, it doesn't violate any law to oppose the TMT project or any application, right? I mean, certainly people are free to and the finding here, or the conclusion, states, given that they are trying to stop the TMT project, it is natural that petitioners and opposing interveners interpret the seventh criterion in this way. It makes no sense, however, and it goes on to
Right, so the seventh criteria relates to subdivision, which is not being used here. So it would be irrelevant from our point of view to implicate a subdivision argument.
So it's okay to characterize an argument that it's natural that because they're trying to stop it, that they would interpret it in this way and that it would make no sense.
Well, I think, and you may be correct, that this is somewhat loose language and maybe it could have been written a little more politely. But I think what they're trying to say is that this is a legal argument that simply doesn't apply here and therefore doesn't make sense.
The questions from the justices gave both sides reason to feel optimistic, and so everyone will have to wait for the court's opinion to see if the project will proceed on Mauna Kea. Then the situation will be in the hands of the next governor for the state of Hawaii. We recently had a chance to hear from the leading Republican and Democratic candidates for the job during a political forum held in Kona. I moderated the discussion.
This is going to be a yes-no question. Representative Hanabusa, do you support the construction of 30-meter telescope?
Yes.
Governor Ige?
Yes.
Rep. Tupola?
No.
Mr. Carroll?
I'm sorry, I didn't hear the question.
I'm sorry. Do you support the construction of the 30-meter telescope?
Very what? 30-meter telescope. Oh, yes, I do.
Okay. I want to do a 30-second follow-up. Rep. Tupola, why do you not support the construction of 30-meter telescope?
I've read extensively the amount of mismanagement that's happened on Mauna Kea, and I'm thoroughly convinced that the first step forward is that we have to fix the mismanagement. The auditor's report 1998, 2005, 2014, 2017. I've read the full comprehensive management plan. The biggest issue that we're having here is that we need to actually fix the management issue, because all of that will not be able to have any type of progress if you don't fix the root of the problem. I would encourage you to read through the auditor's reports.
Thank you. I'd like to sort of stay on that, which is sort of actually it's going to be a 30-second question, and the big issue is whether University of Hawaii will be able to renew the master lease for astronomy on the top of the mountain. So do you support the renewal of the master lease? And I'm going to ask each of you this. Rep. Tupola?
We discussed at the legislature this year about a different type of management authority, and it's something that we should heavily consider, because seeing as though these recommendations from the auditor came years ago, decades ago, and none of them have been implemented, all 8 suggestions given by the auditor, none of them have been implemented. We have to think about whether or not it is the right managing entity to be able to handle a project of this nature. And we also have to make sure that as we read through that comprehensive management plan, that we make sure that it's not just the master lease, but the subleases that UH has been given out and their ability to have accountability.
Mr. Carroll, do you support the renewal of the master lease for University of Hawaii to manage astronomy on the mountain, please?
Yes, I do. And the reason I do is when I was in the House many years ago, they gave 1/3 of the control of the mountain to Canada and 1/3 to France, which I thought was idiotic, and the last third goes to University of Hawaii. As far as I'm concerned, the Hawaiian culture has been based upon Hawaiian navigators, and I think that that telescope basically represent a furthering of the astronomical involvement, and I think that it's the best thing to do. To stop it at this point is going to be absolutely ridiculous. So.
Thank you. Governor Ige.
Yes, I do support the renewal of the lease for university. They should and will be required to do an environmental impact statement. I've also asked them to return 10,000 acres and have the university only keep the 400 acres that are specific to astronomy, so that we can create a different entity to manage the cultural, traditional, and Native Hawaiian aspects of the summit.
Thank you. Representative Hanabusa.
Supporting TMT is a different issue than whether the university should be in control. And I am not convinced that the university has been a good steward, and that renewing the lease with them should be the way that we should proceed. I think come the 21st of this month, we'll hear the final arguments before the Hawaii Supreme Court on the specific issues. But I think that we need to move forward on TMT, but we need to move forward with good faith to show people that we have learned from the problems of the past.
Thank you. I'd like to continue on this topic and ask a 90-second question, and it is, if you are governor and if 30-meter telescope is granted the right to continue and proceed, what will you do to ensure that construction can proceed? That the 30-meter telescope folks can get to the top of the mountain, that they can do their building. Mr. Carroll, is my question clear?
Well, as far as
90 seconds.
Yeah, all I'm saying is that it should be, if it's going to happen and we're going to go forward with it, it's a privatized matter, we should not be spending any taxpayers' money on it. If I understood the question.
The question is more, when previously, when 30-meter telescope was at that time, given the okay to proceed, they were not able to get to the top of the mountain. They were blocked by people who did not want them to go up to the mountain. So the question is, if they are granted the legal right to do that, I'll give you another minute, Mr. Carroll. What would you do to make sure they could actually get there?
If it's blocked by the court, you mean?
No, sir, by people standing in the road.
Well, that's why we have law and police officers, so it shouldn't be allowed as far as I'm concerned.
Ms. Tupola, 90 seconds.
The issue with enforcement, and this is what everyone should know, is that it stipulates specifically in the auditor's report that there is no administrative rules for the mountain. So when an agency gets the authority to manage an entity, the first thing they're supposed to do is create administrative rules. Why do you need that? So that when incidents happen, that you have a way that you actually can proceed with protocol, with rules, with enforcement. I actually talked with the chief of police when this whole episode went down because everyone was confused on what we were enforcing, what are the rules, what are the regulations. So that is actually part of the management issue we're having, is that the administrative rules have never been completed. Therefore, BLNR sent their DoCare officers over because it was their lease. Even the BLNR officers didn't know what to do. So again, back to the root of the problem, the management issue lies in that there are 8 specific steps that have not been abided by, and you need to go through them in order to do it. Part of making the administrative rules requires getting community input and allowing everyone to weigh in. And that's why some of this hasn't proceeded. And so in order to address that question, it has to go back to the fact that each of those steps has to be taken.
Thank you. Representative Hanabusa, if 30-meter telescope is given the legal authority to proceed, how would you ensure they can actually get to the mountain and do the building?
This is an issue that's been troubling me since at least 2015, where I taught UH Law School, and this was my final exam question to my students. I will tell you this, one of the things that we all have to step back. And the first thing we have to step back and analyze is that what people do not know is half of Mauna Kea, the lower half, is actually the property of Hawaiian homelands. And the road that goes up there is an issue because I believe they have not executed an extension of that lease for the road. It's a totally different state governmental entity that technically has control over access. So in order to address access and in order to address those who are protesting and who call themselves the protectors of Mauna Kea, we must first understand who technically has control over access. And I think that what we've all done is we've ignored the fundamental threshold questions, which is who does? And if you look at the debates back in 1920, when the United States Senate debated whether or not the Hawaiian Homes Commission Act should become law, that was one of the major points, is that 50% of Mauna Kea is to be in the control of the homesteads. So let's begin there first.
Thank you. Governor Ige, if 30-meter telescope is given the legal okay, what will you do? Tell us in 90 seconds to make sure they can actually get to the top of the mountain.
Certainly, what we have done and what I did the previous time when we were preparing to enforce the law, it's very clear that I'm committed as governor and chief executive to assure that everyone's rights are protected, that those who want to protest have the ability to protest, and those who are permitted, if the Supreme Court rules that the permit is valid, should have the right to proceed. We did convene, I asked the Attorney General to convene as the state law enforcement officer, law enforcement from throughout the state, to develop a specific plan to provide safe access for those who are contracted to construct the facility. And that did involve law enforcement from Hawaii Island. Obviously, Hawaii County Police will be a big part of that. It included enforcement officers from DoCare and the Sheriff's Department, as we know that it will be a big challenge to assure that everyone's rights are protected and able to proceed. But it is a good example for utilizing the Attorney General as the state's law enforcement officer to organize law enforcement, identify the issues that are involved with getting access, and then being able to implement a plan that assure that the law is enforced.